Good morning, everybody. Welcome to the Courtroom Files Live, where Thursday is the new Friday. It's super busy out there as everybody's trying to squeeze in their work before the holiday weekend begins. Let's start our day with Judge Simpson.
Yes, there is a sign of next right from here.
Seven sworn.
Raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth. Yes. Raise your hand. Michael Scott Collins.
All right, sir, this court's understanding that you're going to be pleading no contest to 2 charges. Is that your understanding? The first charge being the added count 2 of larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
Yes, Your Honor.
The other is the added count 3 of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand all of that?
Yes, Your Honor.
Do you understand what a no contest plea is? All right, 2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanted to contest these charges. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also that, sir, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes.
Okay, understanding all of that, you still wish to plead no contest.
Yes.
Basis for the no contest plea? All right. Sir, to the charge of larceny 200 to 1,000, how do you plead?
No contest.
To the charge of use of methamphetamine, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
That's correct.
All right. You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. Court has been provided and has reviewed Ann Arbor Police Department reports for their case number 2510459. Actually, 2 reports I reviewed. Counsel, any objections to the court having reviewed those reports?
No, Your Honor. No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis. The court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
You were satisfied. Satisfied.
Court will accept the defendant's no contest pleas to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be May 20th, 2025, 9 a.m. before Judge Valvo.
Is it possible to get any later sentencing days? He's working out on these inpatient treatment right now, so probably will be in inpatient treatment at that time.
You can certainly arrange that with Judge Valvo's office. That is the date that we have. Okay. Okay. There's a stipulation for release of treatment, which I've signed.
Yes, Your Honor.
And also, we signed a community corrections location tracking tether, so that he would have to be placed upon that prior to his release to inpatient treatment. All right. So
Tether is a mental treatment. Tether to get.
if you're released on a PR to treatment, they're going to put a tether on you before they send you to. Got
I
it.
do appreciate you letting me go to treatment.
Absolutely. So in that respect, with those modifications, bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Brian Brown.
Good morning, Your Honor, and good morning to your staff. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Brown. I believe Mr. McQueo is appearing for the Attorney General.
That's correct, Your Honor. James McWheel, appearing on behalf of the state.
Had a bench warrant for his failure to appear,
Yes.
but
I was asking that it be a set aside, Your Honor. I think that was entered when we interpreted the date as, that was maybe in January. We interpreted the date for it to be an afternoon date, so we signed on it at 12, and you issued the bench warrant at 9. And it was you were unaware that Mr. Brown was in federal custody at that time, so he didn't appear. He doesn't have any capious history, and we would appreciate that being set aside because he is trying to negotiate a bond on his federal matter, which I don't represent him on that case. But I know that they're trying to do something about it. Mr. McQueel reached out to me yesterday. Unfortunately, I'm in trial. I'm being called in to do a closing argument on a murder case right now. So, but I didn't not want to appear before you, Your Honor, and actually always enjoy appearing in front of you. But notwithstanding, I have not, we have not gotten any closure or any further, and I'd be asking to adjourn this. He is in custody. There's a pending child support matter that requires addressing also, which led to this. So I didn't ask Mr. McQueel. He did send me an email. I just didn't get a chance to get back to him.
all right. I will set aside the bench warrant. I'll reinstate his previous bond in this case.
Thank you.
And then we need to set this for further proceedings. Did you want this set for a PCC?
Please, it's not a, it's not an exam, it's, yes, a
Right.
PCC would be fine.
Set a probable cause conference, okay. He's in Sanilac County, so I'm gonna need 3 weeks for the real, at least. I don't have the 8th, I have the 6th, it's probably not enough time, so I'll set it for May 15th.
Thank you, Your Honor.
May 15th, 2025, 9 a.m.
Thank you so much.
Thank you, Judge.
I'll have a visit with you, Mr. Brown.
All right. Thank you, folks.
Thank you.
Thank you. All right. Bye, Judge.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday, or what is essentially Friday. This will be our last show of the week, as it will, for most courts, be their last court session of the week. Most of them will be taking tomorrow off for Good Friday. But we have fun here. If this is your first time here, we hop around different courtrooms, and as of this morning, apparently we share culinary advice in the chats too, so we just have fun. Let's say good morning to Judge McNally real quick.
Mr. Fallon, tell him I'm not taking that. The party, Connor Army with the party, 25R51421. Your name?
Connor DePatti.
You're gonna plead to impeding traffic, right?
Yes, sir.
To that charge, responsible or not responsible?
Responsible.
Please accepted, 150 is your total. Yes, you're right.
Okay, thank you, sir.
Ernest James Simpson. 258147605.
Yes, sir.
John, take that to Mr. Fallon, tell him I'm not taking it. Your name?
Ernest Simpson.
You owe 198. Should have come and talked to me earlier. Why'd you wait so long?
I'm currently not working. I'm doing
You
Insta.
gotta come and talk.
Gotta talk about something here.
You have any money today?
No money today.
When can you pay this?
I was trying to set up in the
I
regular.
know, tell me when you think you can pay this.
Uh,
I can set you up on a payment plan.
right. Well,
But listen,
is it every,
I don't care, weekly, bi-weekly, monthly, doesn't matter.
monthly would do because my car payments are about weekly. So
Tell
monthly.
me how much you can pay and when. Not that hard to get along with unless people don't show up, which you already did, and I don't wanna go into that.
Okay.
Yeah, but
well,
anyway,
is it
3.5 months.
the total cost is what, 198?
Correct.
So $50 monthly, is that fine?
You're not working at all?
I'm doing Instacart and DoorDash. So
You're asking for a lot now.
I would do that. I mean, that's who's working with me. I mean, well,
I know it. We're not a bank either. You pay,
I pay my car insurance to pay off my car. My car is bi-weekly payments and
you pay $35 bi-weekly. I'll give you some leeway time. You start that on May the 2nd.
okay.
Think you can do that?
Yeah, that's fine.
Now, listen to me. If you don't have the money, I'm not gonna lock you up.
Mm,
All you gotta do is call the court, go on Zoom, or you can come in on or before the due date. I don't care if we have to do that 38 times. I don't have a problem with it. Just don't ignore me. That's disrespectful, right?
Oh, yes.
Okay?
Oh, yeah, appreciate it.
All right, no problem. Good luck.
All right, thank you.
You're welcome.
You like, go to the clerk or get paperwork or?
You don't, if you wanted to print you out something, you will do that for you. Will you print him out a payment,
Yeah, what was the start date you cut out?
May 2nd,
May 2nd?
35 bi-weekly.
Okay, got it.
Thanks.
Thank you.
Michelle, good luck. Michelle Marie Nickel, 25F243538A. Name?
Good morning, Your Honor, Michelle
Why
Marie.
didn't you show up third?
I have no excuse that's justifiable, Your Honor.
That's a good one. It's at least an honest answer. You have a right to a lawyer. If this is a bribeable suspense charge, I'd be happy to give you a lawyer if you want. You want one?
Yes, sir.
Okay. You go out and talk to the I'm sorry, you go out in the hallway. And my court officer will bring this up. He'll set you up with a lawyer out there, okay?
Yes, sir.
All
Thank
right,
you.
good luck. Wait a minute, I'm sorry, ma'am, come here. I apologize. I have another one here, 24R513722. This is Judge Essence.
Yes,
Your name?
Michelle Marie McNichol.
What are you doing? This is from 2020.
Yes, sir. I thought avoiding it was
Good thing.
the right answer and it
Write
wasn't.
this down. Get it on Facebook. Tell them what the judge said. You're making a big mistake if you start doing this.
Yes, sir.
I'll set you up with a lawyer on this one. Good luck. Michael Richard Clark, 25F243995.
Yep.
Could I have Stafford seated at the table here? Max Stafford? Just kidding. Okay. All right. Your name?
Michael Clark.
All right. You got drunk driving here. You have a right to a lawyer. Want a lawyer?
I was hoping I could get reduced without one, but if that, you don't think that'd be the case, I would.
It's up to you. I can't tell you that. I mean, I can arraign you if you want. I can turn you over, send you to the prosecutor. You can see what you want, what you can work out. If you think, just listen, just listen. If I won't give you that, then you can come back in and say, Judge, I want a lawyer.
What's, I'm sorry, what's an arraignment?
Explain to you the charge, the possible penalties, and your rights.
Okay.
Okay?
Yep.
Yes, to do that,
So you explain it and then I can,
talk to the prosecutor. Prosecutor doesn't get any reduction, and you come back in and say, I want an adjournment, tell the prosecutor you want an adjournment, you come back in and tell me, Judge, I want a lawyer.
yes, sir.
You want to do that?
Yep.
Okay. On March 22nd of 25, it is alleged that you did operate a motor vehicle while you were intoxicated in the city of Flat Rock on Gibraltar near a church in Flat Rock. At 2:29 in the morning, that is a misdemeanor punishable by up to 500 fines, 93 days jail, 360 hours community service, point loss or 6 points, license suspension or revocation in accordance with your record. Your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice and rights form here?
Yes.
Fully understand your rights?
Yes, sir.
Any questions on the rights?
No, sir.
If you plead guilty at any time, you'll be giving up all those rights, whether it's the discharge or any other misdemeanor. You understand that?
Yes, sir.
All right. So if you still wish to waive your right to a lawyer, enter a not guilty plea, I'll give you a personal bond. You don't have to post any money. And I'll send you to the prosecutor. Is that what you still want to do?
Yes, sir.
$500 personal bond. You don't have to post any money, but you'll owe the people of Flat Rock $500. If you violate any of these terms, no alcohol, no illegal controlled substances, no marijuana, you cannot leave the state without the consent of the court or violate the law. You must appear in court as directed. Do you understand all that?
Yes, sir.
Okay, do you have any questions?
No, sir.
He's gonna take you to the prosecutor in Flat Rock, you talk to him, he doesn't give you what you want, you can come back in, like I told you, and tell me that you want a lawyer, okay?
All right, thanks, sir.
Good luck, Travis Jerbine, Stafford, 1672211.
All right, let's go back to Judge Simpson. His courtroom's really busy this morning.
Ask for this specific matter, but leaving they get it up.
All right, I'll pass it. Court calls case People versus Desmond Burton.
Assistant Public Defender Chelsea Bridgefield, with dockets Desmond Burton. Mr. Burton, please state your name.
Thank you.
Now, we are asking to adjourn today. I was able to speak with the prosecution this morning, and we're continuing plea discussion.
May 1st, 2025, 9 a.m. Bond continued. Court calls case People versus Marvin Sullivan. Where's he? He's not up yet.
No, we're not.
They're not there.
Nope.
All right. You're there, Sullivan.
David, I don't see the bring on behalf of the defendant.
Your name, sir?
So, we're sitting this matter for exam, Your Honor.
All right. All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 29th.
Your Honor, I don't have a problem with sitting for the 29th. I do have a trial scheduled for the 28th, but I'm thinking that matter is going to resolve, so.
Preliminary examination in person, April 29th, 2025, 9 a.m. before Judge Barr. Bond will continue. Thank you. Court calls case of the People versus Mercedes Cobb.
And then on behalf of people. Good morning. Coaching.
All right, what are we doing?
At this time, we would like to set this matter for exam.
All discovery is complete. I don't know what that means. Guys use those fancy words. People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination in person, April 29th, 2025, 9 a.m. That's before me. That's before me. Bond continued. Thank you. Court does call the case People versus Devin, is it Gothorpe?
Assistant Public Defender Hannah Apple here on behalf of the developer. We take it to the record.
Yeah, I got that, Your Honor.
Thank you.
You're harassing of this matter, set for a preliminary exam.
Discovery is complete.
Yes.
People have their witnesses available the 29th. Sorry?
We'll do our best, Your Honor. Sorry to make you up.
You did. Preliminary examination in person, April 29th, 2025, 9 a.m. That's before Judge Barr. Bond continued.
Thank you.
Court calls case of the People versus Antoine Coleman. Really? She was just in the room.
I'm here.
No, I know you're here. Where's Akinruli?
Your
Oh,
Honor,
great. I sent Cannon to get her. We'll never see anybody.
Your Honor, I believe she's in the lockup speaking. Fine.
Does she want to stay there? Then I need her here. I need somebody up here with this gentleman.
Assistant Public Defender Hannah Apple on behalf of Mr. Coleman.
Yes.
Your Honor, My understanding is that they're seeking.
Now, here she comes strolling up now.
Judge, I am so sorry.
No, you're not. Go ahead.
Thank you so much. This is Mr.
Coleman,
Antoine Coleman.
we've all been introduced while we were waiting for you.
Assistant Public Defender, Chinaki Carey, I can review on behalf of Mr. Coleman. Mr. Coleman, just state your name for the record already.
He did.
Yes.
Like I said, we've been formally introduced while we were waiting for you.
Your Honor, we respectfully request that this matter be set for preliminary examination, please.
Is all discovery complete?
To our knowledge, Judge. Yes.
Did the people have their witnesses available to 29?
Going to try our best, and I just wanted to confirm my previous response that Mr. Collins had to a misdemeanor with the acceptance into a treatment court. So I want to confirm that they are not interested in deleting. They are rejecting that offer, potential offer.
All right, then, Judge, Mr. Coleman would like to adjourn this matter if we could, so we can look into that.
Probable cause conference will be adjourned May 1st, 2025, 9 a.m. Bond continued.
Thank you.
Yes.
Yeah, no, I was gonna stay here for those.
Okay. Thank you. Court does call the case, People versus Robert Lewis. One. 6, 7, 8, all 8 cases.
Good morning again, Your Honor. Robert Ellen standing in for attorney of record, James Michalski. In this matter on the case ending in 1-3.
And Assistant Public Defender, Chinaki Carey, Your Honor, on behalf of Mr. Robert Lewis on all of the other matters.
All right. Mr. Lewis, you have no problem with Mr. Elman stepping in for Mr. Fikowski today?
No, Your Honor, I do not.
All right, very good. What are we doing?
Your Honor, as far as my case, Mr. Lewis wishes to waive his preliminary examination. That's with the understanding that we are seeking a resolution of this matter. Circuit court potentially in drug court. I do have a side waiver here.
All right. Sir, is that correct on this case that you're waiving your right to have a preliminary examination?
Yes, it is, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Elman.
Wait formal reading examination.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
May 7th at 1:30 for Judge Conlon.
May 7, 2025, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond in this case will continue.
And Your Honor, I do apologize. I should have spoken up. I didn't want to interrupt the court, but Mr. Lewis would like to weigh on all of the remaining matters as well. There is a hope for a global resolution in all of the matters.
Got it.
It's always interesting to me how people behave on Zoom. You got the lady in the bottom part of the screen there who's making sure she looks good as she looks at herself. Gets out the lint roller, the whole nine. Judge Fleischer just came online. Let's go say good morning to him.
Now is a condition of your bond not to drive any vehicle whatsoever for any reason until you have a valid Texas driver license and liability insurance in your name. You will be signing an affidavit. This is a promise that you're going to make to me that you're going to drive. I don't care what's going on in your life. I don't care if there's a burning building and you need to save 50 kittens. If you get into a car and drive, every time you do it, it's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine. Do you understand? Yes, sir. This is the affidavit you're going to sign. I don't care if you have to work. I don't care if there's a baby being born. I don't care if Jesus needs a ride to church. Do not drive. I'm going to have you come up here, swear to us that you're not going to drive. Do you have the ability to hire a lawyer, Mr. Espinoza? Do you have the ability to hire a lawyer?
I hired one.
Judge, Brian Levine signed on this morning.
Yeah. Oh,
At the Sully attorney this week.
okay. I guess let's do this. I'm gonna have you swear to us you're not gonna drive. I'll get you to Victoria, sign a reset, and then we'll have you take a seat while we wait for your lawyer to get here. Do not leave until he gets here and we have you sign a reset and excuse you. All right? Come on.
Judge, counsel is approaching on page 24. So, come on up.
Say 50,
24.
24.
The 17th, April 17th.
What number of last time?
No, Your Honor,
That it?
I'm on top of
counsel,
this.
yes, counsel graciously gave it to
Thank you, Your
me.
Honor. Loving the book out this morning.
Yeah.
Ready?
Yes, sir.
All right, Mr. Sosa, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On April 9th, 2025, in Harris County, Texas, an officer was dispatched with a call for a suspicious person. The witness stated there was a spam mail in the back of the business causing a disturbance. The witness stated that the mail was intoxicated and threatened an employee. The officer went to the bag and noticed the mail arguing with several people. The officer gave several verbal commands for the defendant to stop. The officer told the defendant to be told to be detained for safety. And the defendant continued to walk away and stated, it's always the Hispanic trying to get the Hispanic. The defendant refused all verbal orders given to him, and the officer retained the defendant and identified him by the Texas driver's license. The officer noticed that while obtaining the defendant, the defendant continued to say, why for your broke this step.
What did he do? How did he interfere with anything? I didn't hear anything. Hispanic on Hispanic injustice or what?
Additionally, Judge, do we know that this was being told to him in Spanish? He's clearly not an English speaker.
You losing?
Your Honor, the only thing I have is that the officer was recommended to continue to walk away from the
He's
officer.
walking while Hispanic or what? No, I'm gonna find no probable cause. All right, sir. There are people, when they drink, they become very happy. They are the life of the party. And there are people who, when they consume alcohol, they become the devil incarnate. If this is you, it's probably not a good idea to drink. Now, I'm finding no probable cause in your case, but be careful. You know, we have enough violence in this place as it is. All right? Please, take a seat for me.
I have one more, Your Honor.
Okay.
Cameron Newell.
English.
Thanks. You heard that, Mr. Gold?
Yes, sir.
What are we doing with Newell?
So Newell, I evaled the case. There's some significant issues with the case. I explained all of them to the state to make their evaluation easier, and it's a reset for dismissal eval.
Oh. All right, so I'll give you a week. Is there, okay, is there an offer on the case now?
Yeah, Your Honor.
If you don't mind, please put an offer on. We'll give you a week.
One for reset appearance waived, because the next setting is going to be dismissal. It's going to be an offer, which is likely jail time, and we'll need one setting to determine what to do.
No, they're going to put an offer today. It's already 180 days. By then, it's going to be nearly 200 days. I'm not going to continue to do this. You're going to get the offer today. That way you can explain to him, have everything done, come back and let us do it next time.
Yes, Judge.
Got it. 1 week must appear.
Wednesday.
You can use well, supposed to be. Did you give me a date on dual, Judge?
A week?
A week.
I don't care, whatever he wants.
Next judge is page 16, Murphy.
You were Miss Murphy Smith.
Yes.
Ma'am, you're charged with theft. You're facing up to 6 months, 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On September 29, 2023, a law enforcement officer was dispatched to a residence and made contact with the complaining witness. The complaining witness stated that the defendant and her mother took items from her vehicle and would not return them. The complaining witness stated that she had been contacted by a friend informing her of the theft and that the defendant had stated she was going to spend all of the complaining witness's money and max out her credit cards. The complaining witness inspected her vehicle and found her belongings missing. The law enforcement officer spoke to the defendant over the phone. Excuse me, ma'am. And the defendant admitted to taking the items and refused to return them when given the opportunity to do so. The approximate value of the items taken was $600.
Okay. Ms. Murphy Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness, not to go where they live, and not to go near their car. These are your bond conditions. If you violate these conditions, a warrant for your arrest will be issued. You will go into custody. No more PR bonds. Do you understand, ma'am? Yes.
Yes, sir.
You have the ability to hire a lawyer, ma'am.
No.
We will have you fill out an application. I'll take a look to see whether you qualify. If you do, we'll provide your lawyer today. Deputy Miranda's going to give an application. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box and then don't leave until we release you, ma'am. Okay, please. Can you file all those conditions, please?
Yes, Your Honor.
All right, Judge, next is page 19. Ramon, come on up.
Just to update you, I've currently got my eyes on 11 different courtrooms. Everybody's real busy, but Judge Fleischer's popular. He's fun, and this is the busy part of his docket, so we'll just continue to ride with him for a few minutes.
Yeah.
Okay. Monstavai? Is the co-defendant on today, Victoria? Is the co-defendant on today as well?
Yes, but not present. They were on the jail docket yesterday, so I wanted to put this out. And then they didn't.
Oh, did you take a look at Monstavai? She's on deferred. And it looks like that may be at no bond, so you didn't get her today, Dip? Right?
Well, they
That's-
populated on our bond docket, in the last week.
Oh, and more.
Yes, but yeah, they're on the bond docket.
I don't know about this weird, but it's just been.
Okay. Mr. Ramon, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On April 9, 2025, in Harris County, Texas, an officer was dispatched to a theft at Target. The officer arrived and made contact with loss prevention employees who stated they observed two Hispanic females, later identified as the defendant and co-defendant. They were in the store selecting merchandise and placing items in a shopping cart, specifically concealing some of the items in a baby car seat while one was pushing the cart. While this defendant, was adding merchandise to the shopping cart, she removed the price tags from selected items. Meanwhile, the co-defendant walked through the makeup department, selected 3 items, and placed them in the baby car seat, along with other items they had previously chosen. The co-defendant then proceeded to the jewelry department, where she selected a purse, and both females then moved towards the front of the store, approaching the cash registers without making any pay for the items in the car seat, and exited the store. Without attempting to pay for the merchandise in the shopping cart that the co-defendant was pushing. The defendants were positively identified from previous AFI smoke shop photos, and the total value of the items taken was $150.98. Okay.
It's Walmart?
Target, Your Honor.
Target. Ms. Ramon, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any target for any reason. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail, no more PR bonds for you. I am also ordering you as a condition of your bond not to have any contact, hang out with, or be with Ms. Monsivais. Do you understand?
Yes, sir.
If I find that you're hanging out with her, likewise, you will end up in custody. If you don't have anyone to pony up $5,000 to $10,000 to get you out of jail, you will be stuck like Chuck in there until this case is over with. And I'm telling you, it'll take 9 months just to get, certain types of evidence. Do you understand? What do you do with yourself these days?
I stay home, taking care of my mom.
Did you graduate from high school? What are you going to do with the rest of your life, ma'am? If you need something to do, this is not the right way. That conviction will kill you because people know, you need something to do. When people have too much time on their hands, they become self-destructive, man. You need something to do, and now's the time for you to figure out what you're going to do with the rest of your life. You only have so much time. Before you know it, 5 years will pass. If you've done nothing, you're either going to, hanging out with the wrong crowd and be reliant on a man. You need to be strong as a woman. Never rely on a man. Knowledge is power. We're going to work on that. Do you mind appointing her a lawyer? So what we're going to do now is I'm going to have you go to Victoria, sign a reset. We'll have you take your seat in the jury box. I'm going to find you a lawyer here, and then we'll figure out how we're going to go forward. Don't become a danger to our community. Don't hang around with the wrong people. They're just going to bring you down. You understand, man? Okay, come on.
This way. Go ahead and sign here, Lisa. Next judge is page 7 and 8, Finley, or Finlay.
Yeah.
Next one, judge, is
Linkman, I don't know what the answer is, other than don't steal at Target. I've said this before on the live. It's been over 30 years ago that I worked for Target now. And back then, their security system was crazy good, like Fort Knox level. It's only gotten better. You're not going to get away with it there. Just don't do it.
Over, 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 and over. Now on our fourth. You now stand charged with prosecution. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On April 9th, 2025, in Harris County, Texas, an officer is conducting an undercover investigation and observed the defendant walking on the side of the street. The officer observed that the defendant was exposing part of her breast and made contact with the defendant. The defendant asked the officer if the officer was the police, to which the officer replied he was not, and the defendant gestured with her hands a 100, indicating values. The officer, from training experience, recognizes to be a tactic used by prostitution workers to mitigate verbal conversations because they're aware of police reporting tactics. The officer then whispered 100, 104. The officer gestured a closed fist, entering and exiting the officer's mouth to indicate oral sex. The defendant then nodded her head up and down to indicate a yes response. The defendant then told the officer to get a room at a nearby motel. The officer stated the defendant gestured a 2 and 5 to indicate the price of the hotel room. The officer left the scene and gave the predetermined bus signal, and the defendant was detained. The officer stated the defendant was positively identified using her FBI.
Okay. I'm going to find that there's probable cause to go forward with your case, ma'am. Here's what we're going to do. I'm putting a monitor on your ankle now, and I'm forbidding you from going to any street from these cases that you've been on, if I find that you do, I'm going to revoke your bond, put you in jail, and I'm going to make your bond high. It stops today. Do you understand? The next thing that we're going to do, I will appoint you a lawyer, but it's time for you to get a real job, a 9 to 5 job, one where you actually work, get up, go to work for 8 hours, and then go home. I'm going to bring you back in 2 weeks, and I want to see what you have done to fill out a gajillion applications. If nothing gets done, it's not going to go well. Do you understand? But this stops on our 4th, no more. And if I find that you're engaging in any type of way, do you understand? So I'd like to look at all the streets for every single case that we've had here, and then we're going to forbid her from going to any of these streets. I want it to ding and a GPS monitor so that we know she's not going to any of these streets. And we'll go from there. I'm going to have you sign a receipt with Victoria, and then I'm going to have you take a seat in the jury box while we work out all the details, man. Please.
Judge, purpose of the monitor other than the exclusions, did you want a curfew or anything?
Yeah, I guess so. Right. Yeah. Let's do a curfew so she's not out in the middle of the night.
7?
No, I mean, I don't want to be restrictive like 9 to 6. Yeah. I don't want her going anywhere near any of the streets on any of those prior cases. No drugs, no alcohol, and must get a full-time job. Ready?
All right, Judge, page 7 and 8, Finley.
Morning, Mr. Finley. Is it Finley? Mr. Finley. You're charged with evading arrest or detention and unlawful carrying of a weapon. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, I'd like to start out by prefacing that the unlawful carry is based on the defendant being under 21 years of age.
Okay.
And then I'll proceed with the.
Yeah.
On April 10, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance with a weapon call. The 911 caller gave a description of an individual with a gun at an intersection. And law enforcement officers, upon arrival, found a defendant who matched the description in the intersection. The defendant looked at the law enforcement officers, marked the car, and ran from the law enforcement officers. Law enforcement officers then said to the defendant, "Police, stop," and the defendant disregarded the command and kept running. The defendant then ran into an apartment complex and met a dead end, then stopped running and was detained. The defendant.
So they saw the gun on him. They saw him with a gun.
Your Honor, I don't know that they saw him. It's after he was detained, they found the gun in his front right pocket.
What led them to him in the first place?
There was a 911 call. It seems the 911 caller did see the gun.
Okay.
And then the officers were dispatched.
That's the description of this dude with the gun.
Yes, Your Honor.
So cops come, he takes off. Okay.
And then he was detained after evading for approximately 100 yards. And then the law enforcement officers searched the defendant and found a pistol in the defendant's front right jacket pocket, a small bag of marijuana in the defendant's front right hand.
Okay. Here's the problem. You're on felony probation. So I'm going to find that there's sufficient probable cause, Mr. Finley. Let's do this. Do you mind appointing him a lawyer today? And then we'll have him talk to a lawyer. For now, you are not to use alcohol or dope, be in possession of a weapon. You're on felony probation where you're looking at 2 to 10 in the penitentiary. You're supposed to live life as if you have a halo above your head, Mr. Finley, because if not, you're looking at up to 10 years prison. You understand? What do you do with yourself these days? Do you work? Go to school?
Before that, got arrested, I got fired.
What were you doing?
So
Okay. It's time to get back to the jobs. You need to get a job, and I am making that a condition of your bond as well. If I find that you're not working, just doing nothing all day, it's not going to go well for you. I'm going to test you like crazy. If I find that you're using, it's not going to go well. Do you understand? I'm giving you the opportunity now to not use, because I'm telling you, I will test you 45 days from today. And if you continue to use, it's not going to go well for you. Do you understand?
So.
So back again in 2 weeks to see about a job. And then, so for now, I'll have you go to Victoria Center Reset. We'll have you take a seat in the jury box while we have you sign bond conditions. You will meet shortly here with pretrial for your bond conditions. All I want are my streets to be safe. You do anything to my streets. You understand me? Come on.
Your Honor, just to clarify.
I'm finding probable cause on both cases.
Both cases, yes, Your Honor. Thank you.
Yeah, he's on felony probation, you know?
Yes, Your Honor.
All right, Judge, that was the
Is that it?
last arraignment.
Great. Hi, Lori. What's new?
I'm approaching on Candace Gibbs. She's charged with failed to ID. I was,
Jail?
I was asking for a PR bond.
The only case she has open is the endangering upstairs?
Excuse me?
The only case she has open is the endangering upstairs?
No, she has fraudulent use of identifying that came out.
Oh, so she's at no bond on those cases?
From my understanding, I can't see, it says that on there, but her attorney asked me to move her up to get her out. I think they gave her a bond on those.
Ms. Gibbs, please. Ms. Gibbs, yeah. She's on docket. She's on the jail docket.
Thank you so much.
You mind bringing up Ms. Gibbs? Yes.
Counsel for reset?
Joseph, who you got?
Judge, I've got Benny Hernandez.
How you feeling?
Yeah, I'm not too great, but I'm managing. Judge, we can, this case, we could possibly do a plea on it today if we can do it all through the portal, if I can sign the documents through the
Yeah,
portal.
I'm sure we can.
Okay.
Do you know what offer you're gonna take?
The state's offered 15 months of probation.
Okay.
This is the second
Yeah,
DWI.
everything can be done through the portal. Do you have your guy's phone number so you can, talk to him
Yes.
outside?
Yes, I do. I believe he's in the courtroom right now.
Benny Hernandez, your lawyer's gonna call you now. Step outside, talk to him about everything, and then when you come back in, we'll get it done. Please. Okay, Joseph, we'll get it written up and put in the portal for you.
Thank you. All right.
Sure thing.
Your question,
Do you see a bond on the 2 felonies, on the fraud and there's 2 fraudulent cases?
While we're waiting for the next contestant to come out, Bailey, pretty sure job application asks if you're arrested, are you a felon? It's going to be hard to get a job. As a guy who's hired hundreds of people in my past life, I can tell you, yeah, that makes a huge difference. I will say, at least for me, there was some consideration as to what the crime was and how it related to the business that we were doing, and how much time had passed and if there was any growth there. So it wasn't necessarily a 100% you must be disqualified right now, but certainly a factor. Looks like our contestant is here.
They just didn't do that. That's how this was coming.
I'm not sure why.
There like two Bs then?
There,
She hasn't signed it.
She's had recess since
Okay. So
What?
April 8th, 15th. Your next court date, 30th.
She just went to court, she got picked up on me.
I don't know why the court hasn't addressed these yet.
Okay, so Ms. Gibbs, the reason I'm bringing you out now is that your lawyer is asking for me to give you a PR bond on your failure to identify oneself. I don't know, you know, I have to look at what's going on in your life to see, should we give you a PR bond? Are you a danger to the community? I
Not
mean,
at all, sir. Not at all. I'm a college graduate. I've got 4 kids I need to take care of. I have a job. I have a vehicle. I have no problem getting to court at all. Like this, the last 2 court dates that I had with my felony, I had a miscarriage and I was in the hospital. And they're aware of that.
everybody tells me it's little bunnies jumping in the woods.
It's,
You know?
that's the only thing it was. It was, I had a for real miscarriage.
I get it, but you're on bond for a felony endangering a child.
Mhm.
You've picked up 2 fraudulent uses. And now, after those 3 cases, you've now picked up a 4th case of failure to identify oneself. So
They were all in this.
Stop.
Okay.
You have the right to remain silent. I just want to know what's going on to see whether we should give you a PR bond, because this is not a revolving door, you know?
I understand that.
Yeah.
I apologize.
So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay, please.
Thank you. On April 2nd, 2025, the officer was monitoring a neighborhood police radio broadcast. The officer heard a broadcast call for the theft of a department store off of East Sam Houston Parkway in Harris County, Texas. The caller gave a description of the defendant and explained the defendant had just left the store. The officer arrived in the area and found the defendant as she was described by the caller, along with a male individual with the defendant. The officer observed the defendant and the individual enter into a motor vehicle and exit the parking lot. The officer observed the motor vehicle have no front license plate and expired registration. The officer conducted a traffic stop and made contact with the defendant. And the defendant identified themselves as Kathleen O'Brien, date of birth, May 24th, 1982. The defendant stated she did not have any ID card on her person. The officer looked up the defendant by the name and date of birth on the public safety photo, and they did not resemble the defendant. The officer asked for the name and date of birth of the defendant once again, and the defendant gave the same name and date of birth. Due to the photograph not matching, the officer attempted to confirm the defendant's name and date of birth with the mobile FIS. That would turn the actual identity of the defendant as Candace Lynn Gibbs, date of birth July 16, 1981. Along with a Harris County Sheriff's Office mugshot of the defendant that matched the driver of the vehicle.
So they didn't charge her with a theft?
I don't believe so, Your Honor. Or they did not.
So what's going on with the 2 fraud cases that she has that shows like no bond?
Not sure.
Those cases, Lori?
No, sir. I know that she went to court on the 15th, 14th?
15th.
On the 15th on the, I received an email from her felony attorney stating that this was the only case that was holding her in, and to see if I could move her up to get her out.
She said something that they weren't filed or they weren't, or something hadn't been done where.
Yeah, the one, she said they weren't filed yet.
They're filed. I guess the judge just hasn't signed it yet.
Your Honor, it looks like there was a plea offer made originally for the endangerment of a child. And that plea offer has been made now on the fraudulent use case. That was just, I believe, discussed between the felony prosecutor and the defense attorney. I believe that may be the intention, Your Honor, on the cases upstairs.
In this case, Lori, in the fraudulent use case, in her clutch, as they pull them over, she has the identifying credit cards, debit cards of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 different items of other people's identifying information. You are on bond for endangering a child. You pick up 2 fraudulent use cases and now allegedly at a store doing whatever with a failure to ID. I'm not going to sit here and give you yet another PR bond. You know, at some point we have to say when, and now is that time. Your bond, literally $50 to get you out, right? But I can't sit here and continue to just perpetuate this thing over and over and over. All I want is my community to be safe, you know?
I understand that,
So
sir.
I'm going to find probable
In an
cause.
abusive relationship.
Don't say anything, but got to understand that, right, I'm not going to give her a PR bond, Lori. I'm sorry. All right. So, ma'am, what we'll do now, your felony cases are set for the 30th of April. We can set you for the day after and we'll go from there. Okay. Thank you, ma'am.
That's what we said.
Not to be cold or callous, but when she just put in there, "Oh, I'm in an abusive relationship," the first thing that came to my mind was, so what? You don't justify a bad behavior by something bad happening to you. I don't get that one. Linkman, a little while back, you said a professor told you once, "I don't care if you cheat, but you better get away with it. If you can cheat and get away with it, that's a useful skill." Sadly true, especially out in the corporate world. People are constantly skirting the rules, and those who get away with it, not knowingly, are heroes in the eyes of so many, and those who don't get away with it at best lose their job, at worst end up in prison. But it is a thing. So it looks like he's going to go quiet for a minute. Let's say good morning real quick to Judge Meineke, because we haven't seen him yet today.
To have to manage, explain going forward. And that's the beautiful thing about this statutory program that we have is, once you come in for sentencing, we'll be able to move this into non-public status, and you don't have to worry about, even while you're on probation, it wouldn't be known to the public. And then when you're done, it's dismissed. All right, but this is going to depend on you. Is this something you want to do, Mr. Smith? Because I don't want to waste your time or my time.
Yes, it is something I want to do.
Okay, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, please put your hand down. All right, can you state your full name for the record?
Yep, Braden Smith.
All right, can you read, write, and understand the English language?
Yes, sir.
Can you hear and understand me?
Yep.
We had a full chance to discuss this with your attorney?
Yes, sir.
And are you satisfied with his advice?
Yep.
You're pleading guilty to using fraud, deceit, and obtaining a controlled substance. That's a misdemeanor charge, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. When you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to tell, did you use fraud or deceit to obtain a control or to attempt to obtain a controlled substance?
Yes.
All right, satisfied, Mr. Ingot?
Satisfied, Your Honor. Thank you.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. I'll set this matter for sentencing. Mr. Smith will be contacted by my probation department. I need to find out a little bit more information about this young man. It is a little, obviously it's tough to realize that you picked up this charge and made the decision that you did, and it was your birthday, if I'm not correct, right?
Yep.
So you just have to make a commitment that no birthday will ever feel like this, look like this ever again. All right, Mr. Rain, got anything else for the record?
If I may, Judge, just a couple things. I think once you learn a little bit more about this young man, you will be impressed at what he's done, but for this event, or this crime, I'll call it. That being said, Judge, he does, and since February, has obtained a valid medical marijuana card. And so I need to let the judge know that if any kind of testing regimen is going to be imposed.
Well, it's important to know that I'm not ordering any. I'm not ordering any tests right now. I'm sure during the course of the pre-sentence investigation, they'll have them go out for a test. And it may be something that's subject to testing while on probation. But I will make sure that we're aware of that going forward. So if he tests positive, we know, as long as he's using pursuant to the card. But the reality though, Mr. Smith, is if you want to stay out of trouble with this court, when it comes to that, you got to journal your use. All right, so make sure you write down when, why, all right, and how you're using it, okay? Yep. And you cannot drive a motor vehicle within 10 hours of use. You understand that?
Yep.
Okay. If you follow those rules, then the court won't violate you because I'm not going to violate you for use, medical use. All right. Recreational use, we have a problem. All right, Mr. Engat, I look forward to finding out more information about this young man, and we'll see everybody back here for sentencing.
I thank you, Judge.
Thank you.
Several courts have actually gone to recess now, and Judge Fleischer has stepped away, so we'll continue with Judge Meineke for a little while.
Yes.
And good morning.
Good morning, Ms. Roberts Bay, room 6, and Ms. Chupak, room 6. Mr. Steinberg, are you ready to go on Raymore Campbell?
Apparently I was muted. Your Zoom is the only Zoom when I come back in from the breakout room that I get muted in.
And to be fair, you know, with the strength and authority in which you speak, I'm always surprised that any computer software can mute one Michael Steinberg, but apparently it's possible. Wow.
You know, technology wins, Judge. They talked about that before in some of those dystopia movies. So
that's right. That's right.
All right. So she's got all civil infractions, and it actually came out better than what I told her it would last night. So
great. So let's put on the record 25-00411 People versus Jada Campbell.
Michael L. Steinberg, P4341 on Miss Campbell. I only see you. Let me see if she's here.
She's here. Ms. Raymore Campbell's here.
Okay, good.
Just state your name, ma'am.
Jada Raymore Campbell.
Okay. Your Honor, I worked out a little bit better than I told Jada last night. I thought there might have been something to do as a resolved around the disobeying the police officer. Miss Campbell, that charge is dismissed. There's no alternative charge for that. It's flat out dismissed.
Thank you.
So is your bad left turn. So nothing's going on your driving record. You're going to plead responsible to no proof of insurance, which is strike that, a civil infraction, the equipment violation, an impeding traffic, and an expired plate. All of them are civil infractions that are just payable with fines, nothing on your record. So I hope that helps. Your Judge Meineke is going to ask you some questions, and your plea will be responsible, not guilt, not entering the word guilty, the word responsible. Thank you, Judge.
Okay, so Ms. Campbell, yeah, I mean the failing to signal and the disobey, those would all been points. Those are being dismissed. The no insurance, right? That's a misdemeanor, and that's going to be dismissed. So the only ones of your original tickets that you're pleading to are the expired plates and the equipment violation, but those are 0-point offenses, don't go on your record. Impeding traffic is a 0-point, doesn't go on your record. No proof of insurance will still be listed on your driving record, but that's a 0-pointer. So you will have 0 points coming out of this. Is this what you want to do?
Yes.
Okay, all right, so let me just walk through this. So count 1, this police officer signal is dismissed. Count 3, the insurance is dismissed. Count 5, failing to signal is dismissed. All right, so on count 2, which is the expired plates, do you plead responsible to that?
Yes.
Count 4, which is the defective equipment, do you plead responsible to that?
Yes.
Okay. Count 6, which is the added impeding, do you plead responsible to that?
Yes.
And count 7, which is the no proof insurance, do you plead responsible to that?
Yes.
Okay, now, there are fines assessed on all these, but I will give you time to pay Ms. Raymore Campbell. We'll work with you on that. So it does get a little expensive, but I'll give you time. So the defective equipment and the expired plates, those are 130 each, so that's a total of 260 on those. And the impeding and the no proof insurance, those are each 175. So that works out to be 350. All right, 350 plus 260. I love these because I went to law school so I could avoid math, Miss Raymore Campbell, but I've got the total at 610. So why don't we do this? Do you think you could put like $50 a month on these?
Yes.
Okay. So I'm going to set you up on a payment plan and we'll start it a month from now, like middle of May.
Okay.
So on the 15th of every month, you'll pay $50. Now, if you don't have it, all right, don't worry. I'm going to give you a phone number to call. And you just call, and if you need to get payment suspended for a month or need a little bit of time, we're happy to work with you. The only thing that I can't work with, Miss Campbell, is silence. If I don't hear from you, nothing, then we get traffic warrants and increases in fines. Let's not do that, okay?
Okay.
So let's shoot for the 15th of every month, pay the court $50. Here's the phone number that I want you to keep no matter what. If you have an issue of like, how do I make this payment? Those type of things, okay?
Okay.
Ready?
Yep.
248-246-3675.
Alrighty.
All right, so payment plan starting May 15th, $50 a month, and call that phone number if you have any issues, okay?
Okay. Thank you very much.
Good luck to you, ma'am. Thank you, Mr. Steinberg.
You're welcome.
So yeah, it is a thing with judges and math. They're all horrible at it. It's a universal thing. They are all bad at it. And one thing I've noticed from judges on the east side of Michigan, especially, is they're all emphasizing how they're willing to work with people on paying their fines. Just communicate with them. It is a thing on the east side, which makes a little bit of sense given the devastation of the auto industry and stuff over there. It totally lines up. Let's go back to Judge Fleischer.
There's a specifically different one.
That is a video, but remember I said there was a subpoena video just last month that the subpoena that still has not been received.
I don't know.
Here's the thing, I'm looking at the video, okay, we'll sit over there.
I guess do me a favor, speak with him and just see if you guys can get on the same page and then let me know. Okay? Please.
All right, so I can have some very lots. I'll just be reset to the clerk and some follow up with that stuff.
All right, we cut back there just in time to see him be done. That's how it rolls sometimes. Couple housekeeping issues. Number one, this will be the last live show of the week. A lot of judges are going to take tomorrow off, and it just doesn't make sense. And a lot of people travel and everything. So we'll be back on Monday. But we will be posting shorts and regular videos throughout the extended weekend, so we'll still have content for you. So if you are subscribed, if you don't have your notification bell turned on, go to the channel page and hit that notification bell, and then you'll know when we post things. One other thing, if the regulars here might notice that Barbara is not with us this morning. Not my story to tell, so I'm not going to get into details, but what I do feel comfortable sharing is that her husband is having a medical procedure this morning. So if you are a prayerful person, please consider adding her and her husband to your prayers. Let's go back to Judge Fleischer. Yeah, Judge. No, guys, maybe walking away. I don't know.
It's 241 days. I'm bringing them back day for day. Let them know, okay? All right. Tell me.
So, he was out from 3 of this year. The news came back on 26. Now, must came in the system until he got back on the docket. We didn't see that he came back. When he came back on the docket, they were sharing on 20.
Okay.
That is correct. So, I know that in the videos.
Are you telling me that's everything that you wanted?
Yes, sir.
That's everything. That's everything we got back today now.
When did we do the 10-day discovery hearing?
It looks like that.
That was, it's been recent, because I'm not gonna hold them to it if we had the videos already.
The other issue, Your Honor.
I'm not gonna exclude anything.
Right, I mean, here's the other aspect, it was a massive amount of issues. So I can see where it took me a little bit with talking about, oh, shh. It could have just been an issue where, hey, we didn't look. Or none of us looked just because it was a lot of videos, we didn't have time to get through them.
So, and I guess that is the district court case.
Have you seen all the videos?
I have seen the videos.
Okay.
Yes.
Do you have an offer on the case?
So I think there's a 3-year TBC offer.
Oh, he's got a felony.
He's at, it's an so same.
Same transaction?
I told defense counsel, I know we're not sitting here waiting for felony. I did tell defense counsel that it does take something on the felony. The TBC offer.
Obviously.
Dismiss our investigation.
Are you representing him upstairs?
Yes, sir, yeah. We set on the May 19th on that case, so
What's the setting on that?
it's probably.
Oh, okay, great. So if we know that that's where you're headed to, that that's what's gonna happen, then we'll give you the same day. Right, I'm not gonna, if you know that that's gonna happen and we have a roadmap of where we're going, then I'm okay with setting it on that same day for you guys to take care of business then. But let them know if it's not done, if they reset you or what, I'm setting it for trial that day. Yeah? Okay, thanks. Hey, bottom of 15, you set it for the same day as a felony? Oh, look who's back. What a ray of sunshine. Plea or trial on the next one. Same day as a felony.
Okay.
Hi, Anna.
Good morning, Judge. Hi, Bruce.
Yeah.
I've got a couple to talk to you about this morning.
You do the easy ones first?
Well, whenever I have to talk to you, Judge, they're never easy.
That's not true.
Fair enough, fair. But these,
I know. Okay.
the first one is gonna be Wilson Keonje. Start with the less difficult.
Okay.
Can we hear PC on this one?
Is it, you say Keontae? Keonje?
Keon.
Okay, yeah, of course.
On February 6, 2025, a law enforcement officer was dispatched to an assault at Provision High School. Law enforcement officer arrived and observed 15 to 20 students fighting each other and struggling with staff members and security guards. The law enforcement officer detained a number of students. After the scene mostly calmed down, the female was struggling and fighting against male students to run out onto the floor and rejoin the fight. The law enforcement officer approached the males and told them that the female students' hands behind their back. The law enforcement officer got closer to the defendant, turned towards the law enforcement officer, put his arms up to stop the law enforcement officer's progress towards the female and said, "No, no, no." The law enforcement officer grabbed the defendant's shirt and told him not to interfere or he'd be taken to jail. The defendant replied, "I will," and remained in the law enforcement officer's path. The law enforcement officer handcuffed the defendant and ordered him to get on the ground and began pushing the defendant towards the ground and told him to get on the ground again. The defendant remained on his knees, pushing up against being pushed. The law enforcement officer pushed the defendant down towards the wall. The defendant pushed up, causing the law enforcement officer to fall to the ground. The defendant righted herself before continuing to struggle with the defendant to get him to the ground. I believe that's a typo. The law enforcement officer righted themselves.
So there's a fight.
Yes, Your Honor.
The officer is asking him to move, get out of the way, so he can do whatever he needs to get done, and he just refuses to get out of the way.
Yes, Your Honor.
Anna?
So it sounds like the interference is my client doing
this.
He's impeding the path of where he's trying to go or what he's trying to do,
Okay.
right? I mean,
That's what I have you on.
is there a body cam on this?
It looks like we do have a significant amount of video in.
You seen the body cam? Does it show that?
I have not watched them all because it's quite a bit, Judge.
Okay.
But
You remember, it's a low burden.
I understand.
Probable cause, and he's, the officer says, hey, move, man, I gotta get this stuff done. And he's like, no, I'm not gonna move, I'm gonna stay here, just, I mean, I get it's just standing there, but,
Okay,
so look at the video. If you see something different, let me know.
okay. The next one I have to talk to you about is Torrance.
Come up, Ms. Torrance.
I've spoken with the state. And so there's kind of a couple of things going on. I'm assuming you want to do the BVR first. I've spoken with the state. We are going to ask for a hearing. I'll let the state speak for themselves because
Your Honor, we do not have any toxicology bed. We have blood alcohol report, but that is not the toxicology report.
Well, talking about the bond violation
Bond
report.
violation, I apologize.
It's okay.
I apologize.
I don't think the state is prepared to have the hearing today. But
I've got bond violations. The Scram device has confirmed alcohol consumption violations on 3/15/25 at 1:51 PM, 3/23 at 7:14. Confirmation was received 3/25/25 by the analyst, and it's a third bond violation.
I understand, Judge, but those,
Let her go.
the rules of evidence apply at a bond hearing, and we need somebody with personal knowledge or somehow to get around that hearsay to do the hearing, and I don't think the state's prepared to do that today.
We do not have anyone here to do that today, Your Honor. I apologize.
Hey, who do we need? What Scram analyst do we need to get down here? So we can,
Analyst?
right, so they can testify that what's in the BVR.
Let me get that.
I'm sending her now for a drug and alcohol test right now as well.
You're gonna send her for the test now?
Right now.
Okay. Okay. Have a seat, and then once they put the order in, we'll have you go over there. Okay.
She can head over before the drink.
Okay. Okay, go over to 41 Sanderson. Okay.
And then Anthony, do you see, who do we have that can come?
Yeah, I'm gonna
You
get
mind?
a name and.
Yeah, okay,
You go ahead. You want me
we'll
to-
get it. I'm gonna try to get it today.
They'll probably need
Okay, well,
And then, well, so the secondary issue, on Ms. Torrance is we have gotten the alcohol report back. They sent the, blood off to get analyzed for toxicology.
oh Lord, did you just send the blood off?
Well, and Judge, if,
No.
Verify when that.
This case is 233 days old and we have violation after violation. I'm not waiting anymore. She's way too much drama for me and I'm ready to set this thing for trial. I'm not doing it anymore.
For the courts, I did email the person on that side, just got a response. Toxicology analysis still in process, pending completion, it's likely requires some time for the lab board received.
Did you just send it?
No.
Wait.
We've been sending follow-ups. This was like a last Hail Mary attempt of, do we have it or do we not? They still have it.
Do you have other things to go on regardless?
I think we have.
No?
Spoke with defense counsel, there is, I mean, proper, there was alcohol in the system.
Well, look, it doesn't matter to me, however you guys want to do it, but to me, way too much drama. I'm setting this case for trial. That's
Okay.
it, because
yeah, and he has laid an offer,
I need to talk to her about the offer. If it's not moving anywhere,
Okay.
I'm setting it today.
Okay,
Way
and-
too much drama.
just to remind the court, when I was here last time, you gave them 30 days and said if they didn't have the report, that it wasn't coming.
Okay.
I understand the state has to do its job.
Okay, so can you take a look and then, take a look
Absolutely.
and then let's go. But yeah, I'm ready. Hi, Maverick. How are you, man?
Good, good, you?
Sorry to bring you down here.
No, it's good.
Is your client here?
He is.
Should we bring him
Come
up?
up.
I did speak to pretrial and they did confirm that they are kind of in the mistake. We didn't not comply. This is because we did come here to court on a Monday, 4/7. And when you were here, you already knew his results of Bennett.
Okay.
And so you already knew his results and you told him, look, I already know your results. There's no use to test him on Thursday. Because he was on a Monday, Thursday at the time. Let's switch him to once a week. We can't tell him when he would be tested next week, but you know, which day, but sometime next week he'll be tested. So on Thursday, they of course call him and he's like, okay, I already was told not to do it. And then he did not go. And so it put him in the system as a BVR. When he was, in his opinion, following directions.
Okay, I'm gonna send him now, I
That's
guess.
fine. And they even said.
As long as you're
today.
clean, I'm happy. I just don't want anything in your system, especially oxy. You know, that's all I want. I'm not asking for much, you know? We'll send him for a test now. Hopefully he's clean. If so, everybody's happy. I won't ding him on this. You know, if he's dirty, I don't know what we're gonna do. So let's do this, because it's gonna take a while and I know how busy you are. Leave me your cell phone.
I'm trying court 3 all day today.
But I can text you, so that way you don't, you know, don't say it.
Okay.
I'm here. If you write down your cell phone, please, and then I'll text you. All right, just take a seat for me. We're gonna send you here momentarily, Mr. Ben. Thanks, buddy.
Thank you.
Judge, to clarify, Mr. Torrance, if it's possible, if you want to have that bond violation.
If we can, you know, I don't know about the analysts and how soon they can get here, you know?
Pretrial messaging to see if they can possibly do it.
ASAP. Hi, come on.
Judge, I just have one person on docket, parents were you Macero Barcenas?
Senas.
That's his second last name, Judge. First last name Macero, Macero.
Okay, tell me.
I believe our last court setting, we were offered a decision-making course for dismissal.
Okay.
I sent it to my client. I believe he started. I just haven't received a certificate, but I believe maybe he might have finished. He just hasn't sent it. I was gonna ask if I just get a little time to confirm whether he's finished.
See how old it is. It's 191 days old. He's had since April. I'm
Yes, sir.
sorry, since March 4th to get it done. Is he here now?
No, his appearance was waived today, Judge.
We'll set you off a week.
Yes, Judge.
Got to be here in a week.
Absolutely.
Tell him if he doesn't get it done, I'm gonna roll him day for day in 3 weeks.
Excellent. Sounds good. Thank you, Judge.
Finlay.
Streeting.
Good morning, Judge. I'm
Hi.
actually on intake and I'm just here for Mr. Finley.
What's the last name?
Finley. Yeah, Kambamba. How do you say it? I can't find his I
I
can't
still
find
don't, let's see.
Jalen Finley. It's Fin or Finley? Finley.
M as in Mary,
The first name is Jalen.
but the last name?
Find
F, okay.
Lay. Finley.
Is he in jail?
It says it's on bond.
Oh, you got the new case. I see.
That's
That's
a new case, yeah.
Gotcha. So he's on felony probation. I've ordered him not to use. I told him I'm gonna test him in around 45 to 50 days.
Okay.
I'm bringing him back in 2 weeks to see what he's done to get a job as well, just reading. So he's not
Got
just doing nothing. May 6th to the 8th, Ms. Reedy.
May 8th is great.
8th, 8th, yeah. I hear.
Thank you, Judge. May I be excused?
Well, hold on.
Oh,
Let me
okay.
just admonish him in front of you.
Okay.
Anthony, can I talk to him real quick? This is the lawyer that we've appointed to represent you, Ms. Freedy. It is your responsibility to stay in touch with her. If she tells me she can't get a hold of you because you're playing games, you pick up a 4th case, it's not going to go well for you. Do you understand? Keep my streets safe. Okay? Do you have Mr. Finley's application so I can get, I'm sorry, Mr. Finley's application? So I can get
I had it here. What do you need?
I want to get the, I want to chat her the cell phone so she has it.
Oh, I can email it to her. I have her email address.
Okay,
I'll do it right now.
Victoria's going to email you his cell phone so you have it, okay?
Thank you, Judge.
Okay, yes, Ms. Freedy. Have fun.
Happy Easter.
You too. Q, you ready? Joseph, I'll hit you up next.
All right, Judge. Stephanie Alcantar.
Okay.
And I submitted a mitigation packet and the state and I have come to an agreement where they're going to have 16 hours of community service and then a parenting class.
A what?
And a parenting class.
Got it. Okay.
So I was going to see if we can get, a couple of weeks.
Yeah, we'll give you 2 weeks. Okay.
If we can do 16 hours. So I.
She here?
Yes.
You might bring her up.
Yes. Ms. Alcantar?
She's not doing anything in life then, because it's already nearly 200.
She's a single mother and she watches her kids and then also all of her families, their cousins and relatives' kids as well.
Alcantar, they've given you a great offer where they will dismiss your case if you do 2 things, 16 hours of community service and a parenting class. How long will it take you to get the 16 hours done? Okay, done. The quicker you do it, the better it is for you. The only other thing I'm going to tell you is don't bring your proof on a bar napkin. It's got to be at a legitimate place like the Houston Food Bank or something like this. Don't wait till the day before court to get it done. I would start on it immediately. All right? Okay. All right, guys, have fun. Okay, Joseph, are you ready?
Judge, I haven't received the plea paperwork in the portal yet. I'm waiting on.
Shoot, and I was just getting worked out on Chino, and I'm filing.
You're filing it right now, Joseph.
Okay, thank you.
There was a hiccup. Yeah, give
All
me
right.
a cue.
So I missed it because I was looking away, but I assume it was Joseph who was there in Zoom who was scratching his belly, putting it all together. If I'm right, it doesn't surprise me. People are weird on Zoom. It's kind of like if you're driving down the road, the people who will, this is gross, but it's true, we've all seen it. You're at a stoplight, you look over, and the guy next to you is picking his nose. Because they think in their car nobody's watching them. And for some reason, Zoom, people seem to look at it the exact same way. It's like they don't think anybody's watching them. I don't know. Maybe it's because I do this and I'm on camera every day that I'm more mindful of exactly what I'm doing when somebody else is looking at me. But a lot of people just don't seem to have that skill set, I guess. So let's switch gears for a minute and go over to Judge Boyd. We haven't seen her yet today. Let's say good morning to her.
All right, so your attorney's filed a motion to withdraw?
Yes, Judge.
All right. All right, so they're saying they're having problems communicating with you. All right, so, oh, no gum chewing. That's okay. It happens. Don't swallow it though. Our parents would always say it would mess up your intestines. All right, so let me explain something to you about communication with attorneys. I've been a defense attorney. I've been a prosecutor. Sometimes attorneys will tell us things. We don't like what they say. So then we say, it's your fault. This profession has to be the only profession where if somebody's in trouble, they blame their attorney. And I understand that. But usually when people have a medical issue, if they have a heart problem, they don't start blaming the doctor. It's your fault. I have a heart problem. Their whole thing is, what can I do so we can resolve this issue? But with attorneys, when you have a case, sometimes why hasn't my case been dismissed? Why am I not in jury trial? Why hasn't this happened? So what I can tell you, if the issue with your attorney is, hey, why am I not in jury trial? It's because we have cases that are set before yours. If your issue with your attorney is like, you haven't got my case dismissed, attorney can't force the state to dismiss your case. If they want to dismiss it, they'll file a motion to dismiss, and then it'll be up to me to sign it. And if I don't want to sign it, I don't have to sign it. So if that's the issue, this motion to withdraw is not going to be granted because you need to communicate with your attorney. And what I can tell you, if you're not speaking to your attorney, you know what's going to end up happening? You're going to end up going to a jury trial with an attorney that you have never spoken to, and that's going to be your fault. How old are you? All right, you're 50. So it's not like you're 3 and people can't communicate with you. So she's saying she has a problem communicate with you. Step back, communicate with your attorney. You understand? All right, thank you. All right. Sure.
Judge, to finish short.
Yes.
I know that we've been waiting a long time for him.
Yes.
We have.
Okay.
However, Pat Hancock wasn't given notice and he's out of county. He's asking for it to come back Monday.
Okay.
All right, let's go ahead and go back to Judge Fleischer.
Competency restoration, so if we can see if either of those options would be appropriate for him.
Huh?
Yes.
Yeah,
Thank you,
great.
Judge.
Yeah, just, do you mind putting it in the queue on, it's on Elma Zoop. Page 32? Yeah, 31 and 32. Yeah. So everything's been already filed, right? So he just put it in the queue?
So the 2 orders are ones that should be in your order database, but I'm happy to confirm that those are the right ones once they've been pulled up for you.
No, I don't.
It's usually, we can take a, yeah.
I don't usually file it.
No, it's usually should come from the clerks have it in their database.
Yeah, that's one of the documents that needs to be signed.
So the order for competency restoration, and I can give you the statute if you need it. And then I can show you the other one, but it's called Order for Clinical Assessment for Outpatient or Jail-Based Competency Restoration.
That one. We'll get it. We'll get it, but it might take a
And I can show it.
Let's show them.
Okay, as soon as I get it, we'll sign it.
Wonderful, thank you, Judge. And then
Do me a favor though, do you mind maybe like email all 3?
Vegetable, and then I'll give yes, definitely. Give me that. Oh,
yeah, I'm here for mental, so. No. So I'm gonna go. I can work in 2 places.
so long, probably.
Yes, so, yes, you should send it, there should be, a 50 or send a packet off to this.
Yeah.
Okie dokie. Well, he's between things. Address this. Bodie wants to know where I got the drawings of various judges. So Mrs. the Courtroom Files and I, we've mentioned we've got a lot of different businesses that we do and things that we run and whatnot, and we are artists, though I will admit that particular art is not my own. We are also huge users and huge believers in artificial intelligence, not to do things for us, but to make our lives easier. Those judge images were actually created with the assistance of an AI, but you have to know how to prompt it. You have to know how to use these tools to get the result that you want. And I thought I did a really good job, so I went ahead and used them. If you don't know how to prompt things, you just won't get the result. There's a whole art just to that, and it's a thing. But like I said, we are artists, so I wanted to share with you real quick. This is a painting that I did that actually hangs off camera here in the studio. So this is some of the kind of art that we do. But we are also jewelry makers. We make jewelry. That is one of our businesses as well. So we keep busy. We do a lot of things. Just thought I'd share and also answer your question. Admittedly, the judge art is not directly my own, though I would argue there is an art form to knowing how to get AI to assist you to get the results that you want. Let's go to Judge Meineke.
Right, and understand the English language.
Yes.
Can you hear and understand me?
Yes.
Have you had a full chance to discuss this with your attorney?
Yes.
And are you satisfied with your attorney's advice?
Yes.
Right, you're pleading guilty to allowing an unlicensed person to drive. That's a misdemeanor charge, carrying with it a maximum possible fine of $500 plus costs and or up to 93 days in jail, all at this court's discretion. Impeding traffic is simply a civil infraction. It carries with it a fine. And we'll get you into Operation Drive because we got to figure out how to get this license. All right. Before you enter a plea, you should understand. What's that?
Let him finish and then we'll explain. Mr. Smith, let us finish. Yeah, let him finish. Yep.
All right. Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. Monica, can you run a new record for him, please? You've had the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Sir, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes, Your Honor.
Once you plead guilty, there'll be no trial. You understand that?
Yes.
Has anybody promised you or threatened you in any way?
No.
It's your own choice to do this?
Yes.
All right. February 21st of this year, 2025, were you in the city of Berkeley?
Yes.
Did you allow an unlicensed person to drive your vehicle, that person being you?
Yes, Your Honor.
Do you plead responsible to impeding traffic?
Yes.
All right. Satisfied, Mr. Abdo?
I'm satisfied.
I too am satisfied. The plea is knowing, voluntary, and accurate. I will accept the same. All right. Now, I believe he was trying to give me an update. Is there new information about his license?
Yes, paid his ticket in Oak Park. He has an appointment Monday with the Secretary of State to pay his reinstatement fee.
And then he'll have to renew it. So
He has to
basically,
renew it. Yeah, I'm sorry, renew it, not reinstatement. Yeah, the renewal fee. Yeah, but yeah, he's good. That's what we identified it at arraignment and he got on it.
how about that, Mr. Smith? That's what we do. We try to get people focused on that it's not impossible and it's pretty close. So I'm just going to adjourn this for sentencing in a couple weeks. We'll do it on a Thursday afternoon. You don't have to take a day off work. You'll just be able to pop in. Once we see that you got your license, then we'll greatly reduce your fines and costs and give you a payment plan. All right?
Okay, thank you.
So I will set this for a review. Actually, the review will probably be in about 4 weeks, but like I said, that'll give you time to get everything in order, have your license, and then when we see you, what we can do is just verify you have the license and then give you reduced fines and costs, call it a day. So get back to work, Mr. Smith. I'll see you in 4 weeks. When I see you, you'll have a license. Take care, okay?
Thank you.
Thank you.
Thank you, Mr. Abdo.
Good seeing you, Judge. Bye.
Let's hop back over to Judge Fleischer's court.
Right. And the thing is that the last thing I want is for him to wrap his car around a pole because he continues to get proverbial slaps on the wrist, you know?
And then at this point, that's all you need to do. Okay. So when you send these stuff together for the outpatient or jail-based programs, they'll send us back a report and if He's admitted to either those programs.
So we did submit a PTI litigation packet for him as well, just under the assumption that.
I mean, that's up to you guys. The problem is it's 190 days old, right? That's should have like a long time ago, right?
Yes, it's really.
Let me know if you come back. Otherwise, maybe want to check in and.
They filed it as a second, and I'll tell you, let me look at the information.
Sorry, give me 1 second.
Yeah, it looks like you convicted of a DWI in Lawton, Comanche County, Oklahoma in '01.
Flores?
Yes, Your Honor, it was. There was a DUI. Okay. Sorry, I'm trying to decide.
Take your time, there's no
And like I said, it looks like it's that way. The DUI was dismissed. That's.
It was reduced and wasn't dismissed.
It says dismissed, I think, there's no language on the NCIC.
So it said dismiss and then at the same time, a reckless?
Says, dismissed 2001, guilty, and then a guilty plea for a traffic offense. Then the municipal prosecutor, and then in June, so in. I'm not sure, it might have just been dismissed. Was it, where do you have
It's from the attorney of record. He said that he was speaking with Abigail Balance. From my understanding, the previous introduced a reckless driving equivalent from Oklahoma, and then she wrote back.
I'm sorry, Your Honor, the NCIC just not clear exactly how that transaction.
Yeah, it's not an invest, it truly is not. It is. We got
It's
to.
reduced from a, it was,
I don't really have in Oklahoma. But it is not that DWI. That is.
was it a DUI that got reduced or reckless or an obstruction?
All right, there you go. You're free to go.
Oh, Jane, that's higher. So I misspoke, Your Honor. We did not get a JNS back because there is no JNS from Oklahoma. The only thing I can see was there was a DUI charge, no information on it. It's hard for me to track, but there are no DWI convictions. So it's hard for me to track to see if that charge that we have that was, we don't need the JNS on, was the one that was.
They usually don't file it, just.
Right, because it was a class C. Or well, this is all, so it's the equivalent of class C here.
What do you want? One time serve?
We would like to give that offer to our client today because
I mean, we got to do something today. It's 190 days old.
it's today, but
Oh, it's waived.
could have it coming on the next setting.
Yeah, so what we'll do is we'll set you off a week. Okay, have your client come in so we can take care of it. You know, I'm okay with just, can you go ahead and do the reduction now? How do we?
So, yes, Your Honor, so what I can do is I could, because we're reducing it, basically I can run the plea paperwork, Your Honor, we are claiming,
Well, we'll need the new NCIC regardless, right?
I'm sorry.
We'll need the new NCIC regardless.
Oh, yeah.
Do you know the NCIC by heart? on
In
the
Your Honor,
first?
all the offers you've made, it's within the NCIC. It's
Okay.
within class B.
Is it above a 0.15 or no? Okay, yeah, if you want it, I'm okay with it.
Judge, and also we did apply for PTI. I don't know if that's still on the table.
Do you know, have you turned it in?
And as of yesterday, yes.
So
Oh, as of yesterday.
As of yesterday, Judge.
Do you see that it's been turned in?
So we submitted it to,
So regardless, I mean, do you want the PTI? Is that what you want?
my client would really like that. He would.
So let's, I mean, go that avenue and we'll see if they are, down. You're probably, have you filed mitigation paperwork explaining to them that it's not a second though?
Yes, Judge.
Okay, great. Because they need to know, because they're gonna automatically refuse you if they think it's a second.
That was my whole look before I made this. Once I saw it, and I can tell you, Your Honor, the conviction is for passing on.
Okay. I just want to confirm that you have the image.
I don't know that. It was sent to Lindsay Tizard.
Oh, no. That's, okay.
And Flo Dufolacon.
So let me.
You guys get together. I'll give you a week to 2 weeks to get the response and we'll go from there. Yeah.
Thank you, Judge. I appreciate it.
2 weeks. They're filing the PTI today.
Okay.
Okay, counsel, come on.
Yes, good morning, Judge. I'm here on docket for Miss Roberts, Judge. There's a sensitive matter I'd like to approach the bench on, if I'm allowed.
Yes, let's go back. Counsel.
Yes, sir. So.
Okay, since he's stepped away, let's go back over to Judge Boyd's court.
Subject to court approval, the defense and the state agreed on a $40,000 bond on her MTR.
All right, court is calling 2023 CR 8093 State versus Monica Teresa Wade. Can I have parties announced for the record for the state?
Joseph Acevedo for the defendant.
And are you Miss Wade? You're here requesting a bond, is that correct?
Yes, Your Honor.
All right, is there a proposed agreement for the bond?
40,000, Your Honor.
And any objections to the court reviewing the motion to revoke?
Oh, Your Honor.
And what was the previous bond set at?
20,000, Your Honor.
All right. Court is gonna grant your motion. Court is gonna set the bond at $40,000 and the court is gonna order full GPS.
Your Honor, given the Easter weekend and given tomorrow courthouse is closed, may we have that, that she have it installed on Monday or Tuesday?
No. And based upon the allegations in the motion, no. So it's gonna be full GPS. The fees will be waived. They'll do it at the jail. And then Ms. Ferguson, I need a setting for a contested on this. And if it's not contested, then just let the court know. Yes,
I want to make you aware that I did reach out to the manager to get a court summary and they are currently working on it.
for this case?
Yes, sir.
Oh, well, if you want to proceed on a motion to revoke, we can proceed on the motion to revoke, or either it can be reset.
Okay, we're gonna stay with where we're at, but also, Your Honor, may it be partial so she can continue to go back to work?
No. All right, Ms. Ferguson. I need a contested date. All right, May 12th.
Thank you, Your Honor.
All right, so state, it's set for a contested on May 12th. If it turns out it's not a contested, then it will not be a contested.
You're not.
All right, let's go back to Judge Fleischer.
Judge, I received a time served offer, was emailed to me on Mr. Dr. Byrne. He's the 80 plus retired doctor in Sarasota, Florida.
Okay.
I was speaking with Mr. Van Ness at length. I was going to see if we could try to figure out a way to do maybe like an informal PTI where he does all the bells and whistles and they would nollie. So if, without him having to come back from Sarasota. So if I could have one reset to do that, if not, then
It's getting old,
Yes.
right? It's 190 days old. So how long do you want?
just 3 weeks or so, is that all right?
Done.
Yeah, thank you.
But have you turned everything in? They haven't
So
accepted
we're
it?
not talking about that yet. We're talking about just getting creative with it.
But by then, if there's nothing,
Then I'll either set it for I'll either set it for plea or trial, but I'm just trying to avoid him having to come back to Houston. If we could work something out with it.
Okay. For sure. Good luck.
Cheers. Thank you.
Cheers.
Happy Easter.
You too.
This way.
Yeah, let's not. Shit. It's always a crutch, man. I'll tell you. Especially trying to make lunch for 4 kids. Trying to observe that. It's a nightmare. Well, I've got 4 young kids trying to make lunches and trying to observe it. You know, it's just complete chaos. Making lunch for 4 kids, trying to observe Passover. It's like it's a kick in the ding ding.
We have a Seder.
Oh, yeah. Yeah.
And that was Saturday, sundown.
Was it Saturday? Was it Sunday? I don't remember.
Yes.
I can't remember what I had for lunch.
Enjoy your,
Yeah.
enjoy this Sunday.
Yeah.
Tomorrow we're closed, correct?
That's the best thing.
We're all,
No matter what you observe.
we're all Christians tomorrow.
That's right.
Is the old joke. I've really been, that time. The old joke. What do you want Jewish shopkeepers say? December 26th?
What's that?
Oh, how allergies.
Yeah.
That a good
That's
one?
right. That's fine.
It's anti-Semitic loud, right? That was one of my
I don't think
favorites.
you can. I think it was the wrong word.
What's fun is we can't make fun of themselves anymore. We've lost.
We're all self-deprecating,
We've
right?
lost everything.
Yes.
Right. Thank you, Judd.
Have fun.
Cheers. Hey, I'm gonna drive out and see my daughter in Texas Tech for Easter.
Have fun.
I will.
Do you want
Judge?
That wasn't that fun. Wow, I thought it was part of those things. Oh,
What?
let's see. I'm talking to myself out loud.
Joseph, are you ready?
Yes, I am, Judge.
Joseph has a 2. Are you ready on Hernandez?
Not yet, John, but I'm getting ready right now. The attorney still needs to talk to Tori. He hasn't even talked to Tori.
Oh,
What do you think about?
he's on Zoom.
Oh, okay.
Are you on Zoom or no?
I don't have a motion. Need a motion to give me some vision. That's the attorney.
Hey, we need a motion for community supervision, Joseph. It
Oh.
should look in deeds, look in the portal somewhere.
All right, Judge, thank
In
you.
Forms.
All right.
Just a heads up to everybody, I will have a hard out at the top of the hour today. I won't be able to run long because I do have a meeting shortly afterwards. So just a heads up on that. Let's go back over to Judge Boyd.
Yes. And she only has this one case?
Yes, Judge.
All right, so where are we on discovery?
Is this an abatement of an appeal?
Ah. All right, let me see if I have that. Just 1 second. Oh, see, the problem is they hand me. Oh, this is for the motion to revoke, correct? Where
That's
she
an
was an
appeal,
appeal
a
of-
motion to revoke that, yes, Judge.
All right, the court is calling 2022 CR 8049 State versus Stephanie Cled. Could I have parties announced for the record? And it's really just defense. Yes.
Alfonso Otero on behalf of Ms. Glick.
And are you Miss Cleed?
Yes, ma'am.
All right, off the record for a moment. Norma, do you have that document to forward to me?
Want me to print them out?
No, you can just, email it.
Just send it to you.
Okay. Yes, it did. All right, we're on the record, Cindy, back on the record. And the appellate number is 0825000040CR. All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record. All right, and your attorney is here with you, is that correct?
Yes.
And have you had a chance to confer with him?
Yes, ma'am.
All right, so the appellate court has sent me an order asking me to ask certain questions of you. The first question is whether or not you wish to continue with your appeal.
No, I do not.
Okay. And you understand you can still continue with your appeal. There's an attorney here who would do the appeal for you. So you do not wish to appeal.
No.
All right. Is there anything else?
No, Judge, it's a collateral thing. I've been speaking to Ms. Cleed, and she's expressed some concern about that there may be some miscalculation on his time.
All right.
And so she's asking me to request the court to see if we could check it twice, because the time she was in county from September to January is not counted in her time. Although she's had a release date for May 9, if they counted the date, she would have been released already.
All right,
And
so
also,
this is what I'll need you to do, counsel.
yes,
If you will check with the jail on what time she's given, the clerk should be able to pull it, and they'll be able to pull that for you today, and you can sit with your attorney today. And if there's an issue with the time, you feel it's not correctly calculated, then I will review it. And if I determine it's not correctly calculated, then I'll give you the correct time.
Yes, Your Honor. Will this be done today?
Yes,
Will this be done today?
if you all get it done today.
Yes.
Uh-huh.
All right.
and on that too, that she is participating in the programs for the 820 at state jail. And so she asked me just to bring that to the court.
All right. Well, for me to give credit for that or consider getting credit for that, I'll need some more information from the
them.
clerks.
Yes, okay.
All right,
Thank
thank
you.
you.
I have been receiving emails from, I don't know if it's a family member or who was it?
Oh, we're off the record. Yes.
Her side asking that she wanted to find out about the jail credit. Everything was forwarded to Barbara Paulson and court admin to figure that out, so they were supposed to write her back. I did instruct that family member to tell her to file the,
Yes.
knuckle tones,
Yes.
and then they would check it. So they were supposed to follow up with.
All right, so what I'll do is, well, this is the thing. We are where we are, okay?
Yes.
We're trying to make sure that everything is done correctly, so everybody, let's keep it here. I understand when you feel like you're supposed to be out and you're not out. I can understand that raises tension, but we're trying to solve the problem and see if there is a problem, okay?
Yes.
So what I'm gonna do, I'm gonna send an email to Ms. Paulson and we'll go from there. And Cindy, the record that we just did, could you get that to Ms. Paulson as well? All right. All right, so just give me a moment, just have a seat.
Oh, yes, that's Your Honor. Thank you so much.
All right, thank you. And if you will check with them to see how much time they've actually given her credit for, okay?
Okay.
Thank you. You're welcome.
So yeah, the scratching lawyer seems to be popular. I'm gonna go back through the footage this weekend and see if I can find it. Maybe make a short out of that, because it'll be funny and it'll get views. And we like all of those things here at the Courtroom Files. Let's visit Judge McNally.
Get a hearing or trial, do you understand that? There's no valid operator's license on a person, how do you plead? Yes. On February the 19th of 25, we operated in one of the city of Flat Rock on Gibraltar near Wesley at approximately 10:47 p.m.
Yes.
Did you have a valid license on your person?
No.
Are you on probation or parole?
Yeah,
Are you on probation or parole? Anybody forced you to plead guilty?
No.
He still doesn't have a valid license?
He's in the process.
Please accept it, suspends, dismissed. Anything you'd like to say on his behalf?
Judge, just that, Mr. Corey is in the process of working on.
By the way, I'm sorry, I apologize. I need to ask you to charge expired plate, if you're responsible or not responsible.
Responsible.
Okay, I'll accept that plea as well. So I'm accepting the plea to no loss, dismissing the suspended, dismissing the infected equipment, accepting the plea to expired plate. Anything?
Just that he's in the process of working and to get all these, issues resolved, so this doesn't happen again, isn't that correct?
Anything you'd like to say?
I didn't know my license was suspended and everything. I was pulled over and I actually didn't know.
100 fines, 75 costs, 75 victims' rights, $50 justice assessment, $300 for 60 days, 135 on the expired plate, 435 should total. Can you pay it all today?
Financially, should be.
I can't hear you.
Yeah, he's gonna need at least 30 days, Judge.
How much can you pay today?
Probably 100.
Pay 100 now on the no ops. Balance, which would be 35 on, I'm sorry, which would be, no, I'm sorry. Pay 100 now on the expired plate. You'll owe 35. Pay the rest of that by May the 2nd. On the no ops, you pay 75 more. 75 by May the 2nd. And then $40 a week starting May the 9th. Can you do that?
Yes, sir.
Where do you work?
Where?
Yeah,
In Dearborn, in a restaurant.
okay. So you think you could handle these payments?
Yeah.
She'll give you a printout. Wish you well. Good luck.
Thank you.
Michelle Marie McNichol, 24R513722 and 245F 243-538A.
Good morning, Judge. Nice to get the parent behalf of Mr. McNichol.
Your name, ma'am?
Morning, Your Honor, Michelle Marie McNichol.
So first of all, on the Flat Rock case, for purposes of arraignment, she's standing waiting formal reading.
Yes, Judge.
And then she's going to plead to no ops on that charge with the suspend charge to be dismissed. And then also she's going to plead to allowing a licensed driver to drive on the Rockwood case, right?
That's correct.
So let's take the Flat Rock case first. She signed an advice of right. You did sign an advice of rights form today. Ma'am, if you plead guilty to no valid operator's license on your person on the Flat Rock case, I'm going to dismiss the suspended. Possible penalties are up to 100 fines, 90 days jail, cost of law. You understand that?
Yes, sir.
And I'm gonna kind of cover this with the Rockwood case. If you plead guilty to allowing an unlicensed driver to drive on that, first of all, she's standing wait formal reading on
And the
that.
second one, yes.
If you plead to allowing an unlicensed driver to drive on that charge, on the Rockwood charge, it's Judge Hessens. I'll just take it if you want.
Oh, I didn't realize. I apologize.
That's okay, I'll take it.
Because they gave them both to me.
That's fine. You mind if I take it or you want to go with it?
No, that's fine.
If you plead to allowing an unlicensed driver to drive on the Rockwood case, I'm gonna dismiss the suspend charge on that. Do you understand that?
Yes, sir.
Those penalties are up to 500 fines, 90 days jail, costs for all of those. You understand that?
Yes,
And did you sign, read, and understand the advice of rights form?
yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
Let's start with the Flat Rock case. Charge no valid operator's license on person. How do you plead?
Guilty.
Were you operating a motor vehicle in the city of Flat Rock, County of Wayne on March the 2nd of 25 at 7:58 p.m.?
Yes, sir.
Somebody, I'm sorry, did you have a valid license on your person?
No, sir, I did not.
And are you on probation or parole?
No,
On
sir.
the Rockwood case, again, to the charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
On April 26, 24, were you in control of a 2012 GMC that was being operated on I-75 near Hearn River Drive in Rockwood?
Yes, sir.
To allow somebody to drive that was unlicensed?
Yes, sir.
And that was you, true?
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it to the Flat Rock case to no ops. The suspense is dismissed. On the Rockwood case, I'm accepting the plea to allow an unlicensed driver to drive with the suspended be dismissed on that. I'm ready for sentencing. Anything?
Judge, just that Ms. McNichol, does admit that she should have taken better care to remember her court dates. She did try to make arrangements on the Flat Rock case. She does have some emails between her and Lisa, because originally these two were scheduled for show cause, Judge. So she's trying to get everything situated. And she does understand that she can't be driving without a license. She's got a few issues with her driver's license that she's in the process of working to clear, so she can get a valid license. And this hopefully will not happen again, is that correct?
That is correct.
Anything that you want to say?
I am humbly, sorry for the mistakes that I made, the choices that I've made that led me here today. I am now employed at a Toby Construction. I'm a lead project manager on the 696 rebuild. So I'm taking every measure possible to correct my behavior and my decisions going forward. And I hope to never see you in this capacity again, Your Honor.
I can understand that. 100 fines, 100 costs, 70, I'm sorry. On the no ops, $100 in fines, 75 costs, 75 victim choice, $50 justice assessment, 300 or 60 days on the allowing unlicensed driver to drive. 100 fines, 100 costs, 75 victim choice, $50 justice assessment, 325 or 90 days. Can you call over to Carl and tell them I took care of this so they can mark it off the calendar?
Will do.
Can you pay all this today?
She paid 300 today, Joe.
All right, so why don't you just go ahead and pay the Flat Rock case today?
Okay.
Tell me when you can pay the Rockwood case.
Within 2 weeks.
Want me to set you up a payment plan?
That would be wonderful.
Could you pay 75 a week if I start, May the 2nd?
Absolutely.
75 a week, beginning May 2nd. If you don't have the money, no problem. Come talk to me. I'll be reasonable with you. Well, it's done this 38 times, but for the big day. Okay?
Yes, sir.
You walk in here, you can call the court and we'll go on show. Good luck.
Thank you. I appreciate your time today, sir.
Just for, so the balance is 325?
Correct.
Okay.
So 650.
Yeah, so we'll just go down all the counter, maybe, on the first one.
Thank you.
2444054.
I believe that's the woman that we saw about an hour ago, where she was admitting that she had been ignoring her cases. So it's good to see that she got all that settled. Bodie, surprised that I juggle all of this while working. Yeah, it's a lot. But part of it, honestly, is Mrs. The Courtroom Files and I, since this has taken off, we have committed in our minds that the Courtroom Files is a job. It is yet another business that we run. It doesn't mean I don't enjoy it. It doesn't mean I don't have fun, but I approach it from a business standpoint. So it gets my full attention when I'm here, as do my other businesses when I'm in on those. And yeah, it's just, you have to have the mindset and be good at siloing things. When I'm not working on this channel and I'm into other things, that has my full attention, and you just kind of have to work it that way. So we're going to go over to Judge Boyd's court and probably finish our day there.
All right, court is calling 2025 CR 00279, State versus Karen Garnica. Can our parties announce for the record for the state?
Johnny Rodriguez for Mrs. Garnica.
And are you Ms. Garnica?
Yes.
All right, you entered a plea of guilty on April 3rd. The court ordered a TAP evaluation. According to your plea bargaining agreement, the state recommends community supervision. Have both parties had a chance to review the TAP evaluation?
Yes, for the defendant, Your Honor.
Yes.
Yes, Judge.
Any objection to the TAP evaluation?
No, Your Honor.
All right. State,
No objection.
all right.
Sorry.
No problem.
I just want to clarify one point, Your Honor.
Mhm.
On the evaluation, it indicates that she continued doing cannabis after the accident. It was just a one-time occasion, 2 weeks after the accident.
All right, you shouldn't be doing it at all, because here's the thing. What has happened in this case is something that's devastating to all parties involved. And for you to show the court that you realize what you've done shouldn't be you're taking actions that are legal actions. You understand? Your thought process needs to be changed. Do you have any children? How far did you go in school? And are you employed? What do you do?
I'm sales representative.
Okay. I'm sorry?
I'm a sales representative.
Okay, and what do you sell?
Granite, points.
Okay. And what is your work schedule?
For 8 a.m. to 6 p.m.
All right, Ms. Abrams, this is what we're gonna do in this case. And state you may be excused. Court is gonna find you guilty. The court is gonna sentence you to 10 years in prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be intensive outpatient treatment with probation, and I'm following the recommendation for the TAP evaluation.
Judge, if I may add also, she's from Laredo, Texas, so we're asking the court to see if maybe she can do those things in Laredo, Texas.
All right, there'll be a transfer to Del Rio. What county is that?
It's Webb County, Your Honor, Laredo, Texas.
All right, Webb County. There is to be 120 sober meetings in 120 days. 200 hours of community service restitution. 2-year license suspension. DWI education course. Victim Impact Panel Live. Are you on any type of GPS or anything?
Yes.
All right, there's going to be GPS for 20 days in lieu of 10 days in the Bexar County Jail. And the reason why I'm doing that, because there's overcrowding at the jail and you're employed, and the court is going to find that it'll be a hardship for you to lose employment. So partial GPS for employment for 20 days. Ignition interlock, full term. Do you have a vehicle? Are you driving?
No, but I have a portable breathalyzer.
All right, so it's ignition interlock, full term on any vehicles that the defendant has access to, or there's to be an affidavit of non-driving. And with that, there can be a portable monitoring device, full term. Probation, is there anything else?
Yes, device. Did you want that for her to obtain that in Del Rio?
Yes.
Laredo.
I mean Laredo? I thought you said Del Rio or.
Yeah, he said Del Rio.
I said Laredo. You said Del Rio, but it's Laredo, Texas, Webb County.
Okay. Laredo. Yes. All right. Is there anything else, probation? Is there anything else you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand? Yes, probation?
Judge, I did forget one thing.
Yes.
Did you want field visits if they do field visits there?
Yes. Field visits, one time per month for 8 months.
Thank you, Your Honor.
All right, and we can go off the record. Ms. Abrams, they just sent us, I think I gave it to you and put it on your desk. Supposedly they have a new alcohol monitoring system that's done with the watch. I don't know if y'all are doing that or not. It's only $10 a day, but they're not doing it, all right? All right, in this court, to be successful on probation, communication is key. If there's an issue, you need to let your probation officer know. If you feel as though they're not addressing it, then you can always come back to court. If you think you're going to use, you need to pick up the phone, call your probation officer, tell them what's going on in your life, because I want you to be successful on this probation. And if you don't tell people that you're having issues, nobody knows. And then you look up and you have a motion to revoke. You understand? All right, good luck to you.
Every excuse, Your Honor.
Yes.
Thank you.
Okay, real quick before we go, Bailey, you could see the courtroom files interviewing judges, attorneys, perhaps analyzing court, tough cases, good lawyering, etc. Thinking along those very same lines, I'm sure for those of you who've been around here, you've figured out that my angle on this is to focus less on the drama of court. Not that we don't point those things out from time to time, not that we don't laugh, not that we don't shake our head in disbelief, but I focus less on that and more on procedurally what's going on and why things happen. One of the things that I take heat for a lot in our regular videos is that I throw in about 30 seconds to a minute of commentary at the beginning, and people are always telling me to shut up. Well, I talk because there are things that I want to point out that are going to happen and say, hey, look at this, pay attention to this, think about this, because that's the angle that we take here. And I think it's working because the channel has grown so large so fast. I think people thirst for a different perspective on things. So to go back to what you're saying, the analysis of things, the learning end of things, that's definitely going to happen. I mentioned a couple of weeks ago that we invested a significant amount into this channel for things that you don't see, but one of them is to be able to do educational content at the production quality that I want to have. And we have those things now. We're going to be starting that up. My goal to start out with is to put one of those up a week, probably starting at the 1st of May, where we can cover different topics and learn together. Because the one thing I've discovered over the 6 months of doing this channel is how much we all have to learn about our system and how it works. And that includes me too. I'm not a lawyer. I've thought I knew a lot going into this. I now know a lot more, and I now know how much that I don't know. So that's where we're going to go next. As far as interviewing judges, maybe. I've interviewed people before. I've done it on other channels, and I've done it out in the real world, obviously, because I've been in front of so many people I've lost track. But I will say that my impression is judges have a love-hate relationship with channels like this. I think they like the notoriety. I think they like the celebrity status that it can bring them. But I think it can also bring them some heat, because if they have a case that gets out there and it becomes popular, suddenly the lawyers and the parties involved in that bring it to them and say, oh, I've got a problem with this. And I've seen that happen with a couple of videos that we've posted on this channel, where the person will show back up in court later and go, I went viral. Well, courtrooms are also public places, but there is a love-hate thing that goes on, so keep that in mind. All right, I do have a heart out. I've got to go because I've got a meeting I got to go to in a few minutes. Happy Easter to everybody. We will not be here tomorrow, but we will be back Monday, 10 a.m. Eastern, 7 a.m. Pacific. I hope you all have fun this weekend. If you are of faith, I hope you keep the reason for this holiday in your heart. If you are not of faith, I hope that you have a good time with your family and friends and celebrate springtime and the growth of life and just the beauty of the world. So I will leave it there. Take